HR won't protect you after you complain. And when you complain to HR, it makes sense that you would expect protection. But what most employees don't realize is that once you file that complaint, the company goes into defense mode. HR isn't gathering evidence to help you, they're gathering evidence to see how bad the exposure is for them. They're not required to talk to your witnesses, they're not required to share their findings. Their only legal duty is to investigate promptly and thoroughly, and that can mean whatever they want it to mean. So if you think HR is going to save you, think again. In this video, I'll tell you what really happens after you complain and how to protect yourself before it's too late. So here's something most employees don't realize. Yes, HR is legally required to investigate complaints of discrimination and harassment. But here's a catch. The law doesn't say how they have to do it. There is no checklist, no rules that say they must talk to your witnesses, no rules that say they have to share their results. So when HR says, we take these matters seriously and we will investigate promptly, what they really mean is we'll do just enough to protect the company. In part one, we talked about the myth that HR is looking for the truth. They're not. They're assessing risk. Today, we're going to talk about what the law actually requires and why you shouldn't confuse a legal investigation with a fair investigation. Those are two very different things. Let's talk about their legal obligation, and we'll start with the basics. Under federal law, Title VII of the Civil Rights Act, employers have a duty to prevent and correct discrimination and harassment in the workplace. The EEOC's guidance says investigations must be prompt and thorough. And those two words sound powerful, but the law doesn't define them. So prompt could mean the next day or 3 weeks later. And thorough could mean interviewing multiple witnesses or just talking to the accused and calling it a day. Y'all probably seen that happen. The law gives employers flexibility, and many use that flexibility to do the bare minimum. So this is how employers satisfy prompt and thorough. I've seen internal investigations that lasted 2 days with one witness. I've seen others that dragged on for months with no outcome shared with the employee. I've seen them bring in third parties to conduct the so-called investigation so they seem like they're being really fair. And you know what? Legally, all of those check the box because the law doesn't require that the investigation be fair, only that it happen. They can say, we met with the complaining employee, we spoke to the accused, we concluded the matter internally. That's enough for compliance under the law. And if they documented that process, even if it's a weak one, it gives them a defense in court. So here's why companies do the bare minimum. When a company can show they took some action, they can argue they exercised reasonable care to prevent and correct harassment. And that's a really powerful defense they get in court. It's called the Farragut-Eller defense, named after 2 Supreme Court cases. If HR did an investigation, even a one-sided one, they'll use that to show that they complied with the law. They'll use it to show they acted in good faith. And a lot of times this is enough to let the company off the hook. Because think about it, a company operates through individuals. So if the company knew nothing about what was going on, and they'll say, even if they did, they'll say they didn't know anything about what was going on, they have to count on the employee to report it. So that's why we always say, yes, make complaints to HR. Be strategic, don't expect much, but complain to HR. Make sure you keep all of your complaints, everything in writing. Either get my book from Amazon or journal your own. A journal is a journal. So whether you choose my journal or some other one, the important note here is to document everything. So when they do this investigation, it's going to be very one-sided. So that's why it's up to you to document everything. They're doing the investigation the way they do it because it protects them in court. You need to document so you have protection for yourself in court. Because what happens is employees get blindsided because they think HR is handling the investigation. They're really not. They're working it out so that the company is protected. They're not doing anything for you. And so most employees think that since the company said, oh, we're going to do a thorough and prompt investigation, that they're really going to do what they say. And they sit around waiting for the results. But HR's goal is to close the file, not necessarily to fix the problem. Their report becomes Exhibit A if you ever file a lawsuit. So when they say we didn't find enough evidence, what they really mean is we gathered enough paperwork to close the file. We gathered enough evidence to defend the company if you ever sue us. So here's what you should do. If you've ever filed a complaint, keep copies of every email you sent and received. Document it in this book, my Document Everything book. Whether you use my journal, because this is a journal for documenting everything, which takes the guesswork out of how to document. So whether you buy my journal from Amazon, Document Everything journal, or you use some other journal, the point is you need to document to protect yourself. Write down the date that you complained, who you complained to, and exactly what you said. Put it in that book, either in my Document Everything journal or your own journal. Write it somewhere. Save the names of every witness you gave them, because when HR closes their file, your documentation becomes the real investigation record. You should follow up if you have not heard from them about talking to your witnesses, because this is what I see all the time. Send them an email. Say, I gave you this list of names to talk to as witnesses, and as I understand it, you've not spoken with them. Can you please update me on that? And stay on top of it. Do it in writing. Email them. How's the investigation? Will you give me your an outcome, an update? Have you talked to my witnesses? Create your own paper trail. That's important. If you ever need to go to the EEOC or to file a lawsuit, your notes will tell the story that they will try desperately to ignore. So yes, the law requires HR to investigate complaints promptly and thoroughly. And yes, you should complain to HR, but understand what their objective is. It's to make sure the company is safe, not you. But you still have to complain to them, because the law is not going to look favorably upon employees who don't give the company a chance to correct things. Even though we're not expecting very much from the company, if you don't complain, they get to say we never had a chance to fix it because you didn't tell us about it. So tell them, do complain to HR, just don't expect too much. That doesn't mean they'll do what protects you. Complaining to them doesn't mean that they're going to protect you. They're going to be protecting their defense and their dignity. Just be aware of it, but still complain and still keep your notes. Because if you ever end up in court, they're going to have a file and they're going to say, we investigated. You need to be able to pull out your file and say, no, you didn't. Because I gave you these witnesses, you didn't talk to any of them. You just show everything that they did not do. And that's only going to happen if you take thorough notes, if you document everything. See you next shift.